it is to my discretion that the court holds that decisions on points of law by more senior courts have to be accepted by more junior courts. Otherwise, the law becomes anarchic, loses coherence, clarity, and predictability. Case dismissed.
In the case of Willis and Joyce, the judgment of Lord Neuberger, decisions on points of law by more senior courts have to be accepted by more junior courts. Otherwise, the law becomes anarchic, it loses coherence, clarity, predictability. This led to the binding principle of judicial precedent. Hello everyone, my name is Hazim Ashraf Hishamuddin, and today we will be discussing the decision made by Lord Neuberger held in Willis and Joyce and another. This decision has played an important role in the English legal system. Now, you may be wondering what is meant by the English legal system. There is no agreed definition for the term English legal system. However, F. Cowie and Bradney state that legal systems are there to determine what will happen when people have disputes. Legal rules are also there so people can order their lives in such a way as to avoid disputes. However, where do these laws come from? Now, there are 5 principal sources of UK law. These include statutes, like legislations from the UK Parliament, common law, equity, European Union law, and European Convention on Human Rights. By 1250, a common law system existed. Now, what is a common law system? A common law system is a system of jurisprudence that is based on the doctrine of judicial precedent, the principle under which lower courts must follow decisions of higher courts rather than on statutory laws. Now, the main difference between two systems is that in common law countries, case law in the form of published judicial opinions is of primary importance, whereas in civil law systems, codified statutes predominate. But these divisions are not as clear-cut as they might seem. In fact, many countries use a mix of features from common and civil law systems. This English common law system was exported around the world wherever the British dominated during the colonial period. These include the United States and many Commonwealth countries, contrasted with the civil law systems which are found in continental Europe. Now, imagine that you developed a mysterious illness and that you visit a doctor. He has never encountered this illness before, but remembers that a partner in the practice described something similar a while ago. So what does your doctor do? He consults the other partner to find out what was prescribed. Here it is seen that professionals who are faced with unfamiliar cases seek a precedent to help them arrive at the best solution to the problem. Using previous decisions to help resolve a current problem is a technique we use every day in the court of most legal systems. This is referred to as the principle of stare decisis, which means standby cases already decided, or the doctrine of precedent. The doctrine of stare decisis simply means that a judge who is hearing a particular type of court case does not necessarily have to make a decision solely using his own knowledge of the relevant legal principles, but also similar previous decisions can be used to justify the conclusions reached. Where a judge of a lower court is aware of a legal principle set by a higher court in a similar case, the previous decision must be followed. It is this element of binding which is clear in the English legal system. Now, going back to the question at hand, what do we actually mean when we say senior courts and junior courts? And what do we mean when we say that if decisions of a point of law by more senior courts are not accepted by junior courts, the law becomes anarchic, loses coherence, clarity, and predictability? This will be explained further. With that being said, please give a hand to the next speaker.
Thank you for the introduction. In 1607, a concerning issue was raised upon when King James proclaimed the king's entitlement to decide cases in the Court of King's Bench through his imperial position of what he decided. During the age of Norman conquest, overlapping instances occurred between the King's Court and the local courts. The King Court, known as Curia Regis, was a royal-only court, presided over by the king himself, while the local court were directed by a ruler or one of his stewards. The absolute first judges, back in 12th century, were court authorities who had specific involvement in educating the king on the settlement of disputes. King James further expressed that this is particularly the situation during an irreconcilable circumstance between the judiciary court, as judges are mere delegates and advisors. The case of Prohibitions del Roi finally prompts the beginning of the foundation of courts. Sir Edward Coke asserted the Greek medieval jurist Henry Bracton's pronouncement that the king was under no man, but was under the God and the law. No king can arrest a man. King can only sit on the king's bench. The judgment, however, will be dealt by the court. No king, after the Norman triumph, can give any judgment in any cause which concern the administration of justice that solely belongs to the role of the court of justice. After his affirmation for a distinct line between the power of the monarch and the court, this led to the establishment of the judiciary system. In 1873, Parliament passed the Judicature Act, which consolidated the common law and equity. The same act established the High Court, the Court of Appeal, and provided a right of appeal in civil cases. This statute laid down the role of the point of law, otherwise identified as the question of law, which involves decision-making for a case that will rely on existing resolutions and not on the matters of facts. A point of law involves the interpretation of legal principles that are potentially applicable to other cases. Applying the definition to the question, it means that when a court verdict that requires judicial expertise and province is binding onto inferior courts. Now, the hierarchy of judiciary in England and Wales can then be separated into two sections, the senior and the junior, other known as inferior courts. Senior courts, also known as the upper courts, accentuates on the legal principles of a case submitted. It examines on a case based on evidence previously advised or deduced in lower courts, with a broader perspective involving an increased number of judges and experience. Supreme Court is the final court of appeal for all civil cases and criminal cases from England, Wales, and Northern Ireland, followed by the Court of Appeal and finally the High Court. These courts hear appeals on arguable points of law of general public importance. If its judgment, ratio decidendi, concludes is to be different compared to the lower courts, such as the magistrates, it would then be binding on the latter. The process is appropriately known as the Doctrine of Judicial Precedent, which involves an application of the principle of stare decisis, also known as stand by the decided, onto all future cases concerning similar facts and circumstances which will be bound by the decision as signified and demonstrated in Hadley, Bryan and Co. and Helfer and Partners, as well as White and Jones. Established in the case of Young and Bristol aeroplane, the purpose behind the creation of the doctrine involves several advantages. The principal advantage is the doctrine of judicial precedent in its certainty in law. By looking at existing point of reference, it is possible to forecast what a decision will be and plan accordingly. It ensures inferior court judges a rightfully decided ratio decidendi to fall back on. This will simultaneously help the court system to spare time on future rulings. At the point when the legitimate framework has given a response to the comparative circumstance, then the past rulings can become the foundation of current decisions that is necessary for a case resolution. It indicates a lesser time invested in deliberation, as they already have access to a decision-making process of senior judges, as demonstrated in the use of Caparo Industry plc and Dickman's test when identifying the existence of duty of care. This will be further accentuated on by Uthra. Secondly, it allows for uniformity in the law. Similar cases will be treated in the same way, which is essential to give us the system a sense of justice and to make the system acceptable to the public when the rule is repeatedly chosen over for cases with comparable realities. Consecutively, this reduces the likelihood of floodgates, as when this occurs, party will not appeal, seeing the flow of continuity. Thus, the scale of justice is traceable to the original source, ensuring legislation to be consistent. The legal system at any level have more strength because it provides predictable outcomes of justice. Finally, judicial precedent is practical in nature. It is based on real facts, in contrast to legislation. It is detailed with a wealth of cases to refer. This structure of work then prevent past mistakes from occurring, as one can trace the history of case to distinguish what has been repealed or overruled. It aids judiciary court in understanding the direction of court system, especially the more inexperienced court, and the reasoning behind why an alternate decision was not selected upon or its consequences to the society. That makes the outcome feel more robust than it would have been if a ruling seemed to come out of the left field. Reverting back to the same case, Lord Greene did allow 3 rules of exceptions. Jacqueline shall accentuate further onto these exceptions.
Thank you, Megan, for your interesting discussion just now. So I will be introducing the 1966 Practice Statement. In 1966, the House of Lords issued a practice statement. The first major use of the practice statement was in Harrington and British Railways Board, which overruled the case of Eddy and Dumbrag. In the first few years after 1966, the House of Lords was reluctant to use the practice statement. Strong evidence may be seen in the case of Jones as Secretary of State for Social Services, where, to quote his lordship, "Nevertheless, I am clearly of the opinion that it would be wrong now to seek to depart from the decision for the following reasons. The first reason would be the Declaration of July 20, 1966. The second decision is a variation of view on a matter of statutory construction, so much a matter of impression, would I should have thought, rarely provide a suitable occasion by itself, that it is to say, for it would be different, if it were convincingly shown that a previous construction, clearly demonstrated to be wrong, was causing administrative difficulties or individual injustice." The fourth would be, on the instant issue, there is obviously much to be said for each side. One has only to consider the speeches with which your lordships have already favoured. Although I myself come to a clear conclusion one way, I recognise the strength of the counter-arguments. In particular, there are 4 powerful contradictions on the all-important structural or functional approach. The first would be, if one starts with what will after all be the typical case of the insurance officer deciding the get-away question, the scheme of the Act will make an entirely different impression. The second would be, the conclusiveness is of special value in disputes falling within administrative jurisprudence. The third would be, conflicting decisions on medical matters may lead an unsuccessful claimant for disablement benefit to feel a sense of ill usage. And lastly, the superior apparatus for review of decisions by the statutory authorities, who will generally get in first, is an argument for giving the decisions of those authorities a force. Overriding those of the medical authorities, in particular, it seems to be a defect that there can be no review in the light of change in dominant medical opinion, perhaps by reason of a new discovery. In 1969, there were 2 statutes amending the National Insurance Industrial Injuries Act 1965, and certainly one of those would seem to have provided an opportunity to modify the rule in Dowling's case if this had been necessary. The minister having failed to take that parliamentary opportunity, he should not, in my view, be encouraged to invite us now to take this step, with our far more limited knowledge. So today I will be talking about the advantages of departing from the judicial precedent as well. The first advantage of the departing from judicial precedent through the 1966 practice statement would be flexibility. It is submitted that there is room for the law to change as to the Supreme Court can use this practice statement 1966 to overrule cases and also gives the court some freedom to avoid past decisions and develop the law. For example, in the journal, Overruling the Protectionist Exclusionary Rule, Director of Public Prosecutions and JC, it was pointed out that the Supreme Court could overrule the case of People, DPP, and Kenny in DPP and JC to avoid erroneous decisions from being made, thus promoting clarity. The second advantage is that it reduces the propensity of a per incuriam decision to be made. In Latin, per incuriam means in error. An added consideration on this occasion was that the fact that the Law Commission in the reports had favoured extending the defence of duress is a principal offender charged with murder. However, Lord Griffiths in that case disposed of this point, stating, "But what I think is significant in the fact that although the report recognised that English law did not extend the defence to the actual killer and recommended that the law should be changed, Parliament never acted upon this advice. The House was therefore in agreement that it should again use the practice statement to overrule Lynch." Lord Nottingham set forth the general policy that those who relied on the statements of law are to be protected. This case, Reg and Hudson and Miliangos and George Frank Textiles Limited, if resurrected, he ends up by saying cautiously and skillfully used in exceptional cases where retroactive ruling would be demonstrably unjust, would implement the purpose of the 1966 statement to preclude injustice in a particular case and serve the proper development of the law. Therefore, decisions on points of law by more senior courts have to be accepted by more junior courts. However, does it always mean the law becomes anarchic and it loses coherence, clarity, and predictability? I will now introduce my colleague to further elaborate on this point.
Thank you, Jacqueline, for that very wonderful presentation indeed. Her presentation was very much thought-provoking, and I would really like to draw your attention to why courts should follow precedents. Now, I know it's a very heavy TED Talk, but please bear with me and do not fall asleep. So going back to the question, courts should follow precedents or otherwise the law becomes anarchic and it loses coherence, clarity, and predictability. Now, to make answering this part of the question much simpler, let's break it up into two sections. The first section, let's handle anarchic. And the second section, let's go through coherence, clarity, and predictability. Now, firstly, anarchic means that there are no rules in a society to create order. Now, as we know, laws are enforced in a country to set the standard of acceptable behavior and to create peace overall. Now, Lord Bridge, in the case of R and Shivpuri in 1982, stated that if a serious error has distorted the law, the sooner it is corrected, the better. Now, this resonates with the doctrine of judicial precedent in that decisions in newer cases will correct previous decisions if the decision in a previous case is wrong or erred, and this sets the direction of future decisions in similar cases. In contrast, if judicial precedent is not practiced, courts would decide on key issues concerning a matter at their own discretion, and the law, of course, becomes anarchic and chaotic. Now, a good look at history shows that the doctrine of judicial precedent has been, at most times, in the words of David Strauss, courageous, experimental, highly abstract, and theoretical indeed. To show you an example, the case of R&R overruled the case of Caldwell and made marital rape a criminal offense. Now, the case exemplifies that laws control the behavior of the people and overall creates order and justice. Now, secondly, going to the second section, coherence means consistency in the law. Clarity means a clear understanding on the point of law, whilst predictability means the ability to estimate the outcome of a case. The doctrine of judicial precedent provides stability and coherence to the law because courts are bound by the principles of similar previous cases. Therefore, there is clarity in how the general public will understand the law and how it may be applied to their case that has similar material facts. Now, not only this, lawyers will definitely be able to provide much more better and proper advice to their clients on the likely outcomes of their case because of the predictability of case law. Now, for example, in Shaw versus DPP, the House of Lords held that conspiracy to corrupt public morals was a crime. Now, in the bigger picture, for your better understanding, a major benefit of the doctrine of judicial precedent is that the principles of law are thoroughly explained in the ratio decidendi, which makes the law precise. As the jurist Edward Coke quotes, reasoning in the law is the life of the law itself. Reasoning, as we all know, provides well-illustrated examples for future cases. Not only that, it allows much gradual development of the law in an orderly way, as stated in Castle versus Broom. For example, the privity of contract rule was laid down in the case of Heaven versus Pender in 1883. Now, this rule was further developed into the neighbor principle in Donahue versus Stevenson in 1932. After this, the Caparo Industries versus Digman case in 1990 further enhanced and developed the neighbor principle into what is known as the Caparo threefold test today. Now, the Caparo test, if you look in the overall picture, ultimately illustrates that the doctrine of judicial precedent aids a principle of law to be established, extended, and further developed. Furthermore, development can occur when one case considers the point of law in an older case no more applicable and obsolete, as shown in the cases of Murphy versus Brentwood District Council when it overruled the case of Ans versus Merton Borough Council. Okay, so I see most of you in the audience have not fallen asleep yet, and that's really good, because now I would like to invite my colleague to come and present on possible reformations. Thank you very much.
Thank you very much, Rufa, for the very lovely introduction. And as discussed by her previously, there are boundless benefits arising from the system of judicial precedents, especially with regards to the binding of lower courts. For instance, as formerly mentioned, without such a concept, courts in adjudicating a case could lead to discretionary decisions where deciding elements may be based on purely arbitrary factors. Other issues are apparent, such as the mantra of consistency in law, security, and audio development. However, the system is not without its drawbacks. A recent scolding article by, and sorry for my pronunciation, Jieh discussed how the slow pace of common law's evolution is ill-suited for the rapidly developing technological world of the 21st century and its novel legal issues that demand immediate resolution. For better or for worse, there are some issues which, although do not override the principled benefits, could in due course be corrected. To call any system perfect would be to disregard the duty to improve and to better. It must also be noted that other countries and other systems, such as the United States, place much less emphasis on precedent, alternately advocating for stringent codification of the laws. Classifying American law is a difficult task, as despite 49 of the 50 states officially being common law, the state of affairs which takes place is vastly different from the common law that is seen in both England and Wales. Unlike across the Channel, the American system relies almost exclusively on constitutions, codes, statutes, rules created by various government entities that Congress and state legislators have constitutionally authorized either directly or indirectly to make the law by legislative delegation. The remaining white space on the canvas of American law that once called on courts to fill the intricacies has rapidly diminished, and this trend will most likely continue unabated. A more precise definition may be a label of positive law, defined as law actually and specifically enacted or adopted by a proper authority for the government or an organized juror society. Comparably, the state of affairs in the US are a great contrast to the UK, which in certain areas may prove beneficial if adopted. As formerly mentioned, the US judicates mostly via statutes. The UK, on the other hand, though having primary legislation, derives many rules, specifically the intricacies of various topics, from case or judge-made law. The various positives and negatives to both. For example, the system as implemented in the US is more time efficient. Total judgments will only form part of the introduction in the UK, and in turn easier to understand. The UK, on the flip side, however, may be seen as having a living law, by proxy of its living constitution. It is living in the sense that it changes in response to changes in our world via judicial use of distinguishing and overruling. There may be a fair argument to make that be beneficial to more reconcile statute law and common law in the UK to further fill in the canvas. In today's modern world, the doctrine of precedent could appear to be of antiquity. The rapid-fire acts and events which characterize such cannot be simply sufficed with judge-made law. It is not to say that precedence is not without its positives, very much numerous in number. Its promotion of case law leaves laws lauded in real-life issues. However, the issues of strictness of precedent is shown in the case of Great Western Railway v. owners of SS Moyston, in which the House of Lords had to consider a doubtful, inconvenient case of Weird v. Amundsen. Almost 50 pages of this case are occupied with close analysis of what the latter case held, with even Viscount Haydon pointing out that if he had not been for the Weir case, it would have been possible to take a more simplistic view of the matter. The assumptions of similarities in betwixt cases when there may not be the case may lead to undue inconveniences. Somewhat simple solutions may and have been implemented to aid in efficiency of judicial judgment. The practice statement, as mentioned earlier, has gone a long way in aiding and achieving a just law and system. But being limited to Supreme Court, or formerly House of Lords, it also ensures stability and certainty to lower courts, but allows for flexibility in the meanwhile. However, it must be noted that, as a pure case of English definitions, that the two words are antithetical. The promotion of practice statements should be a priority as it allows the avoidance of repugnant situations as found in the case previously mentioned. As Law Gardner has said, too rigid adherence to precedent may lead to injustice in a particular case and unduly restrict the proper development of the law. The purpose, therefore, to modify their present practice, and while treating informal decisions of the House as normally binding, to depart from a previous decision where it only appears right to do so. I would now like to invite my colleague up to the stage to finally conclude our presentation.
Thank you guys so much for your patience. We will finally be concluding this session. Now, considering that the doctrine of judicial precedent has been practiced in the United Kingdom courts for the past 500 years, it is evident that this legally dogmatic system is effective for better or for worse. The law has developed so much so that there are countermeasures such as the 1966 practice statement, which ensures that the law progresses with modern times and does not stay anarchic. Although perfection is above the legal system's reach, it is key to remember it is an ever-evolving justice mechanism. Thus far, the current system of precedent is sufficient in and of itself. In conclusion, the doctrine of judicial precedent prevails to deliver justice. Thank you.